Okay, good morning, everybody. We're going to go ahead and get started. It's 10:15. So welcome to the session, Extending the Core to Your Court. I'm Kathy Griffin. I'm on the board of directors here at NACM, and I'm also the chair of the new core committee. With me today, we're going to do a presentation on how to use the core material to take back to your court, your colleagues, and do presentations, use it as learning material. We're going to go through two of the competencies. One, purpose and responsibilities that Jude Del Priore will be presenting, and the governance competency that Ray Billett will be presenting. I'm going to go ahead and let them cheer.
I have my own cheering.
I'm going to go ahead and let them do a quick introduction.
How many of you ever done a presentation when your boss was in the room? Second. Go ahead.
Good morning, everyone. My name is Jude Del Priore, past president of the Mid-Atlantic Association for Court Management, past president of the National Association for Court Management, court administrator, Burlington County, New Jersey. Working for the New Jersey Judiciary for over 40 years. I started when I was very, very young. And I was the principal writer for this particular module, and I'll be sharing with you some of the components of that this morning. Last year, I was fortunate to receive the ICM Fellow Award for judicial branch education. So this is something I love doing, and I look forward to spending some time with you this morning.
Good morning and welcome to our session. As noted, my name is Ray Billett, and I am the Judicial Branch Administrator in Maricopa County, or the Superior Court there. I have been there for 4 years. Prior to that, I was here in Pittsburgh for 21 years and worked with many of you in this room that I see, and so I just want to welcome you. I'm not a past president of anything other than I've been on the NACM board. I'm currently the vice president of the National Association of Presiding Judges and Chief Executive Officers. So welcome, and get started.
Thank you. As part of our introductions, yesterday morning I was thinking, Jude gave a little story about himself, and Ray did, and I thought to myself afterwards, I was really going into it very nervous about presenting. And my husband said, how can you be nervous about presenting when you teach? Because on the side I teach exercise classes. So I thought, to get it started, everybody stand up, we're going to do kickboxing to get going. But then I realized I don't have a wandering microphone like they do. I have to stay put. So maybe that was intentional. Anyway, like I said, we're going to go through a session on the new core material, and I'm kind of hesitant to call it the new core as it's been out about a year and a half, but I'm sure many of you are familiar with the NACM core. But we want you to come away from this session with how you can use the great resource, the material that is out there if you're not familiar. So I'm going to go through just a little bit of the history of the revision project, the overview, how it's laid out, how the curriculum components and the resources, and then they're going to actually go into a little more depth into each of the curriculum. So many of you, I'm sure, are familiar with the old NACM core competency, and this was what was called the wheel, with the purpose and responsibilities of the courts being the center of the wheel and everything extending from the wheel. The original core competency educational components were written in the 90s, and many of them were becoming out of date. When Jude Del Priore was president of NACM, one of his goals was to rewrite the curricula to make it update and make it more useful. And the core committee was formed. Paul DeLoche chaired that committee, and it was a 3-year revision project to get us to where we are now. The core competencies have been the foundation for many national training and certification programs. Many of you are familiar with the ICM courses. There's the Certified Court Manager and the Certified Court Executive programs. MSU, the judicial administration, both the non-credit and the credit certificates. They use the core competencies as the foundation for their educational components. As you can see, many of them are listed here. The new core is laid out in three modules. The principal module, there's two competencies within the principal module: public trust and confidence, and purpose and responsibilities. Those are the two curricula that everyone working in the court system, regardless of the position they're in, should be familiar with. The next module is the practice module, with more of the day-to-day operations of the court. The practice module has the most competencies in it. Some of the examples: case flow, workflow, operations management, ethics, budget. And then the last module is the vision module, which is more for the higher level, upper management leaders of the court system to know. And that module is leadership, or the competencies within that module are leadership, strategic planning, and court governance. So this is what the new NACM core logo, and within each module, the competencies are within that module. So you've probably seen this logo here, and as you can see, we have banners. That is, instead of the wheel, that is how the core is laid out now. The NACM core can be found at nacmcore.org. It's a separate website from nacmnet.org. You can get through it through the NACM website, but it has its own website. When you pull up nacmcore.org, this will be the page that will come out. As right here, if you click the core content button, we'll show you on the next screen. That is how you'll get to the competencies. And then within that first page is also one of the competencies. This rotates. It will give you a highlight. Right now it's the ethics. And then at the very bottom of the screen is just a paragraph about NACM. Additional resources that are available regarding the core material. In 2015, the core and practice guidebook was mailed to all NACM members. If you weren't a member then and you'd like a copy of it, you can order that through the NACM store, and also the resources of each curricula. The writers for the two principal module curricula are Jude Del Prior, Purpose and Responsibilities of the Courts, and Kevin Bowling, who is here, Public Trust and Confidence. The writers within the practice module, we have case flow and workflow, Tim Dibble, Workforce Management, Lynn Malloy, Operations Management was written by Janet Cornell, Ethics by Peter Kiefer, Public Relations by Sally Rankin, Budget and Fiscal Management, Dawn Palermo, Educational Development by Karen Thornton, and Accountability and Court Performance by Mike Breidenbeck and Angie Smith. The vision modules, TJ Bement wrote the leadership curricula, Ray Billette, the court governance. The strategic planning was written by Cyril Miller and Ken Pankey. One of the goals of the NACM core revision project and the NACM board at the time was for the curricula to be able to enhance the knowledge, skills, and abilities and educate the next generation of court leaders. They wanted to make sure this could be used for professional development. One of the ways that you can, one example you can take from this would be to use it for new staff orientation. Especially anybody coming into the court system, that is where the two principal modules that everyone should know. I've heard examples, people have them use both of those modules as a staff orientation. Additional needs was that it should stay current with new and emerging trends, basic information throughout the competencies for entry-level staff, but yet have information there for high-level leaders and detailed operational content for mid-level staff. Within the curricula, as you explore it, you'll see each one is written with the same structure. They'll all start with an introduction. Each one will have learning objectives written within there, how to use the curriculum, the NACM core reference, what the target audience is for that curricula, the educational content itself. Extensive faculty resources are within each curricula. There's participant activities built in, notes, special notes within the faculty, and a bibliography page. So this is what you would get to on the table of excuse me, I was looking at the competency. Table of contents page. At the very top will be what competency you're in, which this is an ethics example, and at the very bottom is what module it's in. The design, this is the faculty resource page. And this is the activities page. As you can see, there's many activities built in. And then this would be your bibliography page. So with that, I'm going to turn it over to Jude. He's going to go through the purpose and responsibilities.
Good morning again. So I just want to share with you a quick story. One of my most interesting introductions ever. It came from my son, Adam. And we were at back to school night, and the teacher, I thought, gave very clear instructions, said, boys and girls, please introduce the parent that's here with you tonight and tell everybody what mommy or daddy does for a living. Easy enough. So as it got closer to Adam, I noticed he really started to get nervous. And when it was one away, like all the color drained from his face. He got up to introduce me. Seemed at that moment he forgot that I was working for the New Jersey Judiciary for 25 years. Seemed that he forgot that I was the chief probation officer for Morris and Sussex counties in the Great Garden State. Seemed the only thing he could remember was that I was teaching an introductory course at the local county community college that semester. My introduction went something like this. This is my dad, Jude Del Prior, and he teaches, you ready for this, sadistics. So hopefully I won't torture you too much this morning in our time together. So I wanted to talk to you a little bit about this particular module and the way it's laid out and the way that you can use it. The way that I wrote this module is you can use it for a 1-hour overview and a new employee orientation, or you can use it for a 5-day course. There's enough materials there for you to do that too. And so it kind of starts with how is this relevant to each and every one of us as court managers? And I think the very first line says it right up there, you know, in terms of when we look at the purposes and responsibilities. And as Kathy laid out for you, we're in the principal module, but the competency is purposes and responsibilities of courts. And to test your vision, we want you to read that. No, I'm kidding. But it said, that first line says, the most fundamental aspect of court leadership is an understanding of the purposes and responsibilities of the court and providing the leadership to ensure that these continuously guide court operations, court policies, and court procedures. And so we kind of drilled down to what are some of the key functions and purposes for which courts exist. And we do this in a couple of different ways. But I think one of our colleagues from the Mid-Atlantic region, you know, Suzanne James, she did this whole thing on studying your job and, you know, assessing how much of your day is spent on purposes and responsibilities, and how much of your day is spent on the Constitution and the Declaration. And after all this work, and us team teaching a lot of courses together, we kind of boiled it down to 4 key purposes. The first one was to protect citizens' constitutional rights. The second one was to provide for procedural due process. The third one was to ensure that each case receives individual justice. And the fourth one was to preserve the rule of law. So with those guiding as the underpinning for this particular module, we kind of tried to lay out, and I then took it and went with it and developed really 8 chapters and 8 segments of this particular module. So the first one was purposes of courts, and both looking at traditional purposes of courts and then looking at some of the modern purposes of courts, things that are evolving today. So we start with the basics, and then later in the course kind of talk about some of the new trends, new directions that courts are moving in. The second thing that we do is look at the sources of liberty and justice for all. And this is really a study of some of the key documents that underpin what we do. Starts with Magna Carta in 1215. We take a look at Article 39, which basically provides for the movement from rule of man to rule of law. And then we talk about some of the things that are guaranteed by Article 39, like habeas corpus and trial by jury. And so some of those things starts there. Then we move to the Declaration of Independence. And, the statement of grievances that, the king has failed to assent to our laws and has made judges dependent on his will for their payment. So all those things ultimately, work their way into our Constitution. So then we look at the Federalist Papers and some of the key Federalist Papers that provide for a strong judiciary and what the need for a strong judiciary is. We then move to Article 3 of the Constitution. You all know Article 3 of the Constitution is one that sets up the judicial branch. And in that, there's one court that's provided for. Can you tell me what court is provided for in Article 3 of the Constitution? Peter? All right, federal court, it's the U.S. Supreme Court that's provided for. But then there's this little clause in there. Clause says lesser inferior courts as necessary. So if you kind of look at the entire federal court system and 54 state and territorial court systems, they all come under that little clause, lesser inferior courts as necessary. And then we look at the part of the Constitution called the Supremacy Clause, that basically all judges, whether state or federal, are bound by the United States Constitution. And then, of course, in that Article 3, it says that our courts have the right to declare laws unconstitutional. Right? It's right there in Article 3 of the Constitution. Right? Anybody? Comes from a famous, it's not in there at all, comes from a famous U.S. Supreme Court case called Marbury versus Madison. And so then we take that and kind of look at us giving ourselves that particular power. It's kind of interesting, a few years back when I was president, I had the good fortune of having Sandra Day O'Connor at our conference in Las Vegas. And she kind of told us when she got up, she said, yeah, you're right, there are 3 branches of government. And the executive branch has the power of the sword. They can declare war. And the legislative branch has the power of the purse. She goes, but we have the power of the pen. And it can be much mightier than either one of those. And I thought that was a pretty interesting way to put it in terms of Marbury versus Madison. So then we look at some key concepts and procedures. We look at the rights of procedural due process as guaranteed by the 5th and 14th Amendments. And so we take it all from timely notice to confronting witnesses to attorneys, representation in the courtroom. And I'll give you one way to take a look at that in a few minutes as we look at some of the activities that we do. Then we go through an interesting look at courts as an organization and courts as an institution. So you need to think about this a little bit in terms of the way that organizations develop. And so there's a continuum. Kind of starts with somebody performing an act. And that act can be the preparation of a court order by a judicial staff person and the judge signing that act. All right. those individuals come together to form the organization of the courts. So each of you represent a court organization. But we become most powerful when those organizations blend into an institution known as the third branch of government. And that's what we need to strive to do more of, and that's kind of what we look at from time to time. Judge Kevin Burke, who used to be the president of the American Judges Association, said, that's what all courts in this nation must do. We must strive to become a third branch of government rather than an office arrangement of attorneys who happen to be judges. And so, he kind of put it out there as moving towards a third branch of government. And so we look at it that way. And we look at the need, basically, to be mission-rooted in what we do in terms of justice and enforce the code and the rules. So overall, this first 4 segments look to explain the historical and societal context for the development of courts as we know them today. And take a perspective from the court management side is what is it that we do that supports judges in the fulfillment of their role in the courts. And so we also look at the need to convey the role of the third branch of government. The next things that we do is we kind of look at court reform and accountability. In 1906, Dean Roscoe Pound wrote an article known as The Causes of Popular Dissatisfaction with the American System of Judicature. We're going to get into it a little bit more in just a couple of minutes. But interestingly enough, in 1906, he wrote about the press attacking the courts. And he kind of talked about, the press saying that we're too soft on crime. Unfair characterizations by the courts in the press, that's nothing we're familiar with today, is it? So it kind of started back then. Then he said, it boils down to 2 things. It takes too long, costs too much. You go to any of the sessions here talking about civil reform, during this particular conference, you're going to hear those same critiques today that he wrote about in 1906. Then we talk about management and leadership in the nation's court, knowing that purposes gives legitimacy to leadership of the courts and underpins the necessity for good case management. So we talk about delay, time standards, and know that we need to manage courts well to do justice. Then we talk about some of the new directions in courts. What do you think is the number one that we hear all the time now for new direction? Give me one. I'll repeat it so that it gets onto the tape. ADR, alternate dispute resolution, technology, all those things, that therapeutic justice are the kind of things that we're hearing now when we kind of brainstorm the new directions. And lastly, a practical application of purposes, how it can apply to each of our individual jobs in the justice system and how we can take it with us. So those are the major components of this particular module. And then it's laid out in terms of that table of contents, as you can see. So each one of them has a section within the curriculum, and then there's subsections that you can follow. But, as Kathy pointed out, it kind of lists it here with the module at the bottom. So they all follow the same particular format. So we developed these learning objectives. I'm just going to review them with you briefly. They kind of support those 8 sections. So the first is to describe why courts exist and the major purposes that courts carry out. The second one is to define the values, foundation, and historical perspectives underlying the American court system. The third one is to define the key concepts and terminology, especially the judicial system's dedication to the rule of law, equal protection, and due process as related to the purposes of courts. The fourth is to summarize the role of courts as an independent third branch of government, an institution, and an organization, and how its role impacts and complements the other 2 branches of government. Remembering that we are an independent branch of government in an interdependent world. So we also need to interact all the time. We look at some trends in court reform and pressures forcing the courts to change and expand. You heard about some of them this morning. at the plenary session. You also hear about many others. There was a whole expose study, an investigative study regarding the California Administrative Office of the Courts. So there's a lot of things going on in terms of pressures to force reform in the courts. Apply the values and goals of the American judicial system to specific court administrative tasks and responsibilities, including dispute resolution, or ADR, as he mentioned. Explore quality court management concepts, such as accountability measures, things like the trial court performance standards that kind of started with that, and the ABA time standards, and now court tools are all things that we're using. Lastly, articulate the practical impact and relevance of purposes and responsibilities to your jurisdictions, your day-to-day court operations, and your job. So that basically are the learning objectives for this particular module. So why is purposes and responsibilities important? Well, the first thing is it's the most fundamental aspect of court leadership is understanding purposes and responsibilities. It's up to us, basically, also to provide the leadership to ensure that purposes and responsibilities continually guide operations, policies, and procedures. And we can't really forget these fundamental purposes and responsibilities of courts, and they apply regardless of specific jurisdiction in which a court functions and provides both the philosophical and legal framework for all daily work. And so when you kind of take a look at it, it's kind of there. Now, this morning's session kind of dealt with Ferguson. If you haven't seen the DOJ report on Ferguson, it kind of boils back to purposes in one particular respect. If you read it, it talks about the DOJ found that the Ferguson Municipal Court has a pattern of practice of focusing on revenue over public safety. And it talks about lending to court practice that violate the 14th Amendment's due process and equal protection requirements. So two of the key factors that we kind of center in on this course are mentioned directly in that particular DOJ study. So, in Lewis Carroll's masterpiece, Alice in Wonderland, the Red Queen, tells Alice, let's begin at the beginning and end at the end. So any discussion of purposes and responsibilities of courts needs to really start with, why do courts exist? And so when we talk about that, we need to talk about what judges do every day and what court administrators do to support that. And so we kind of look at this and, we kind of come up with these major purposes as to why courts exist. And you may have seen these before. They're based on some seminal research that lasted for 35 years with Dr. Ernie Friesen. And we'll talk a little bit about that. But just to highlight them again, it's to do individual justice in individual cases. And in that regard, it's not abstract, it's real. And, it's applying the law to the facts. The second is to appear to do justice, which is a little bit different. It's, that courts need to be predictable in what they do and consistently apply the law. The third is to provide a final resolution, and this concept of finality is important to what we do. We're required to, resolve the controversies before us. And so we get into this concept of finality. So we look at things like collateral estoppel, res judicata, but these concepts of finality. And then protect individuals from the arbitrary use of government power. So we do this through a lot of interaction with the groups. We ask them to brainstorm ways that courts do this. Generally, the two that rise to the top of the list are illegal search and seizure, protecting individuals against illegal search and seizure, and the second one is eminent domain, taking individuals' property without due process. So those are the ones that come up time and time again in the course. Make a formal record of legal status. We spend more than half of our budgets on this, on recording things, and especially in divorces and adoptions, things like that. And the last three have to do with criminal, deter criminal behavior through pronouncement of punishment, rehabilitate persons convicted of crimes through probation and therapeutic justice and drug courts, and separate persons convicted of crime when we must protect society. So as I mentioned to you, this is based on the work of Ernie Friesen, who's a longtime standing fellow in court management. If you don't know Ernie Friesen, he wrote the first book on managing the courts along with Ed Gallus and Nesta Gallus. It was called Managing the Courts. He was also the first court administrator in the U.S. federal court system. So if you have the opportunity to learn from him, it's a good thing. He still teaches, by the way, from time to time at lectures. But a year and a half ago, he produced a new video. It's a little bit longer, and it goes through all of these 8 points. But I think if you go to YouTube and take a look at it, you'll find it interesting. I'm just going to show you one quick segment.
First of those is to do individual justice in individual cases. That's quite a mouthful. It's a rather complex idea. What do we mean by individual? The Constitution of the United States provides for the jurisdiction of courts. They really say there must be a case or controversy. They can't deal abstractly with a proposition put to them. They don't give advisory opinions except under some statutes that have been passed in the last 25 or 30 years. Courts deal with the case before them, and only the case before them, and don't apply the logic beyond that point. So the individual word is important. Cases and controversies is important because it means it's limited to a dispute. Think about that. The adversary system is built into the Constitution. Without an adversary question, we don't have jurisdiction in the courts.
So Ernie goes through all 8 purposes, but it's worth a look. And this one was produced by American University. It's out on YouTube. You can find it out there. So if you're ever having trouble sleeping at night, I would recommend the read of Roscoe Pound's 1906 seminal article on the causes of popular dissatisfaction with the American system of judicature. It's a tough read. I admit that it's a tough read. So we give it as a homework assignment now most of the time and ask the people to come back ready to discuss portions of it. But it's really worth it to look at, what he lays out. He lays out, these 4 causes of popular dissatisfaction. Causes of dissatisfaction with any legal system. Second one is causes lying in the peculiarities of our Anglo-American legal system, which he says makes litigation a game. And that people played this game back and forth between the 2 opposing parties. Also talks about the causes lying in our American judicial organization and procedure. So Sunday I attended the ICM Fellows Leadership Seminar. John Meeks is here. He put together a really good session for the whole day. But Mike Benger came in to talk a little bit about state courts. And he's the state court administrator from Ohio. They just wrote a book that's going to be featured a little bit later in a plenary called American Judicial Power. But during that presentation, he put up 2 schematics, one for the state court system of New York, one for the state court system of Georgia. And they were amazing. They took up the entire slide, and it was this court went to that court, went to that court. Well, right here, in 1906, he talked about the popular dissatisfaction of multiplicity of courts. And, so the issues that were pointed out in 1906 are still with us in terms of some of the things that we talk about. And the last one takes a shot at all of us. He says causes lying in the environment of judicial administration, which means that anybody can be either a court administrator or a judge in a leadership position. He said, and courts are a little bit mismanaged. It's not like we haven't heard that this week either, right? So they're ongoing. So develop, use standards. We kind of talked about some of those already. Trial court performance standards, court tools, and then align on court performance and structure with court operations and purposes. So this is where we kind of have the rubber meet the road, leave the 20,000-foot view and drill down to the current. So we set up for faculty resources, activities, slides, and bibliography. So I just want to show you one thing. So this is an example of a snippet of the beginning of the bibliography for purposes. You'll notice that the second book there is by Alexander Aikman, and it's called The Art and Practice of Court Administration. Anybody ever hear of it? Raise your hand. Okay. So in that, he takes this one piece, which I've excerpted for you, and he's taken, Maslow's hierarchy of needs and converted it to court administration, and kind of talked about, what are the key things that court administrators do, from the basic mission critical operations up to leadership and organization. And then we go through a whole series of activities. So, we have learning needs assessment, purposes of the courts exercise, key concepts matching test, due process courtroom activity, electronic definition search, court reform and activity, which then reforms. What we do is take Roscoe Pound stuff, and then we ask these students to develop a public service announcement of 30 seconds that would support court operations and win over the citizenry to what we do on a day-to-day basis. Some of them are really good. Practical impacts activity to your job, new directions brainstorming. We did it real briefly with you in terms of ADR, but the ones that are coming up, like we mentioned, are alternate dispute resolution, problem-solving courts, therapeutic justice, evidence-based practices, conviction alternative programs, and restorative justice. And then lastly, we go through why study purposes. So I just wanted to briefly review with you a couple of activities. So the first one is this: why do courts exist? And we kind of go through the exercise of having people say why they exist. But what I've been doing recently is sending 2 roving reporters out into the hallways, wherever we're teaching this, and ask the general public to tell them why courts exist. The answers are much different on what they get from the outside of the room to what we get on the inside of the room. So one of the things to kind of end that free video that we've been using. We passed out a key concepts matching test. Take just a moment working with the person next to you and see if you can fill in the first 5 on that list. No, we're good. I got it. Leave that out. I said leave that out. I want you to use it in a minute. All right, I'm going to stop you there. Did you get the first one? All right, so I'll go through them real quick. All men are created equal, H. Right? Declaration of Independence. To none will we sell, delay, or deny justice. B. Magna Carta, Article 40. Collection of judicial decisions, customs, and general principles. L. Common law. Judges in every state shall be bound thereby. K. Supremacy Clause. Created 13 district inferior courts to assist the Supreme Court. D. Judicial Act of 1789. Liberty is to faction what air is to fire. E. Federalist number 10, basically saying that the judiciary is the only thing that can really combat factions in society. Judicial power of the United States shall be vested in one Supreme Court, and United States Constitution, Article 3, principle that all persons, institutions, and entities are accountable to the law. M, the rule of law. Equal Protection Clause, G, U.S. Constitution, 14th Amendment. No liberty unless the power of judging be not separated from the legislative and executive branch. I, Federalist 78. First 10 amendments to the Constitution. A, Bill of Rights. Safeguard from arbitrary denial of life, liberty, or property. F, the Due Process Clause. Right to speedy public trial by an impartial jury in criminal prosecutions. J, U.S. Constitution, 6th Amendment. Authority to determine whether a law violates the Constitution. C, Marbury versus Madison. And if men were angels, no government would be necessary. That's Federalist 51. Oh, so turn that over for a minute. And I'll tell you another exercise that we use, and we're not going to go through this one, but I just tell you how we use it. We use the concept of, by just looking at the setup of courtrooms in the United States, you can kind of talk about some of the rights of procedural due process. And so you go through the process of having people look at the courtroom and see which ones they can list for each of those various positions of the courtroom. So we get things like the right to adequate notice, at the doorway, the right to timely and adequate notice, the commencement of actions, all right? Behind the jury box, right to trial by jury. In front of the judge, we get a lot of different things. Right to speedy trial, opportunity to be heard, impartial decision maker, statement of the reasons on the record. So all of these rights of procedural due process based on the various components and sections of the courtroom. So you kind of get an idea that we have all these things. Last one I'm going to give you, and I'm going to give a prize for this, is we now use the electronics that everybody brings to the classroom. So you could use it in a couple of different ways. You can use people to answer multiple choice questions through polling software. But the other thing is we do this electronic definition search. So that first word that's up there, the first person that finds it and defines it for me, I will give a small token prize to. If you have it, raise your hand. The key is whether you can pronounce it. Come on up. It's a recorded session. I got to get you on the microphone. Speaking to my tie. Here you go.
Is it justiciability?
Let's go with justiciability.
Okay. Concerns the limits upon legal issues over which a court can exercise its judicial authority. It includes but is not limited to the legal concepts of standing, which is used to determine if the party bringing the suit is a party appropriate to establishing whether an actual adversarial issue exists.
There you go.
That's enough.
Isn't it? All right. So that's one of the things we do. There's about 10 different terms in the curriculum that you can use. And since you did that, I have for you the very coveted gavel pencil.
Oh, I've never seen one of these before.
So let me just end my section by a couple of quick thoughts. It kind of all boils down to the reasons that we started with, why we study purposes of courts, because it underpins everything we do. But I'd like to leave you with a couple of quick quotes. The first is from George Washington, and it points out that the true administration of justice is the firmest pillar of good government. We have a colleague that we lost in the last month. His name is Jeff Gallus, court consultant, did a lot for NACM over the years, did a lot for the ICM Fellows Program over the years. But in writing the introduction to the first set of core competencies, he wrote the following: efficient and even effective judicial administration is not an end in itself. Courts do not exist so court leaders, either judicial or civilian, can manage them. Rather, courts must be managed well so that judges and others acting in their stead and in their shadows can do justice. And so it's kind of all boils back to purposes. And my favorite quote is from Federalist 17, Alexander Hamilton writing says, "The ordinary administration of criminal and civil justice contributes more than any other circumstance to impress upon the minds of the people affection, esteem, and reverence towards government." When you think about the ordinary administration of justice, it's each of us in this room on a day-to-day basis. Thank you very much.
Thank you, Jude.
Ray?
I'm still on. Thank you, Jude. We're going to now take a transition from the purposes and responsibilities into court governance. And someone asked me before, I think it was Ann Herod, how did you get asked to do court governance? I don't know. But I was just watching it and I said, court governance is part of vision. So I must be a visionary, right? So, thank you. So anyway, I don't have any exercises for you to do, but I will take you through the curriculum and point out some of the key points of what I believe is important and some of the takeaways that participants will get from this course. I think we'll spend about 15 or 20 minutes on that, and then we'll save all the questions either for Kathy, Jude, or I till the end, so if that works. I forgot that trigger. Excuse me. So, as I said, the curriculum that was developed, that I developed, was on court governance, and so it's important that we start out by really thinking talking about what is court governance. Simply put, it's a framework by which we manage the day-to-day operations of our courts and provide for short and long-term planning. How many of you in here would say that you are functioning within an organization that has a formal organization, formal court governance structure? Thank you. That was good back there. That's my court back there. Our court back there. Thank you. Others? We are? Two? Those of you who are not, how does the work get done? Custom, culture, anyone? Well, what we're going to do anyway, it's all right. We're going to make a case for why it's important to have a court governance structure. And I think really one of the reasons I was asked to do this curriculum is because I've had the benefit in my career of being in leadership positions in the smallest of court organizations, one presiding judge and 4 other district justices, what I would term a medium-sized court here in Pittsburgh, which is with all the judicial officers, is almost 100 judicial officers. And now in Phoenix, where we have nearly 160 judicial officers. So I've had the benefit of being involved in any of those. So court governance takes very different forms in very different places, not only based on size, your size, but also based on your culture. And some of the things this curriculum will do and participants will be discussing will be issues such as culture, how that impacts what you're doing on a day-to-day basis. So this curriculum is really in 5 sections. Excuse me. First, governance history and principles. And I want to talk a little bit more in depth today with you about the principles in just a moment. Governance in today's courts. There is a section discussing organization and governance models that are in place today. And the last 2 last 2 bullets here, building an effective court governance. And I should say it's not just building it, but you could use the word improving court governance, and that section applies as well. And evaluating the effectiveness of your current governance structure are really the heart of this curriculum and what when I wrote it and went through it, what I wanted participants to be able to do after they completed it. Again, this is, I don't want to spend any more time. These are the first page of the table of contents. I don't know if any of you have the entire curriculum with you, but it's 2 or 3 pages. So when someone has completed this course, I expect, you expect, we expect that when they're done, they will be able to obviously define court governance principles and the numerous structures that are in use today. This is an important one, I think, to also be able to define the role and importance of court governance in promoting the rule of law, judicial independence, procedural justice, and developing and maintaining a high-performance court, and the role court governance has in those, in achieving those. Also to identify various organization governance models, be able to observe, explore, evaluate their own court, understanding the complexities, understanding the culture and how it may impact it. Two additional objectives include a readiness assessment, and that's one of the activities I'll talk a little bit more about. There are about 5 activities in this curriculum. There's not a lot. Those who know me know I like to keep the activities and the role playing to a minimum. I'm sorry, not a role player. But there are 5 activities, and one of them is a readiness assessment tool that I developed with Dr. Brenda Wagon Connect Ivy. That's part of the curriculum to help you and help those assess their organization. And also to obviously develop and implement a governance structure evaluation process that will help that court improve their efficiency and effectiveness. Excuse me. So, as I said, we talked about what it is, and we didn't get into many examples. I don't think I have a lot of time here today to get into a lot of examples of what court governance is, but obviously it's things like developing and passing personnel policies for your organization. It's about intergovernmental approving and using intergovernmental agreements with other branches and so forth and so on. But a key component of this curriculum really is to focus on why court governance is important and be able to communicate that not only internally but externally as well. Now these 4 are really, if you think about them and you look at them, framework to operate, consistency, predictability, transparency, and accountability, and promotes meaningful input into the organization decision-making process, are really things that are internal to the organization. And they're very important and very necessary, and obviously meaningful input is something that we all strive for. But I also want participants to think about court governance beyond just that internal need. And when I talked before about advancing the rule of law, supporting procedural justice, and enhancing judicial independence, I think are 3, as Jude has talked about already in his purpose and responsibilities, are 3 very important aspects that court governance can really have an impact on as you go forward. In the curriculum, again, have any of you ever watched the video Fair and Free produced by the National Organization of Women Judges? You never seen that? A couple nods. Yeah, I think if you've never seen it, on page 33 of the curriculum, there's a site where you can go to. But I use that video in this curriculum to get participants to think beyond what the real advantages of procedural fairness, procedural justice are, and how it can be supported by effective court governance. As to judicial independence, we all think of judicial independence from a decisional standpoint, the ability of an individual judge to make a decision in a case without fear of reprisal or influence. But we also have to think about judicial independence from an institutional perspective. And that's what that's the connection between that and court governance. This curriculum also, in 2013, Chief Justice Christine Durham and State Court Administrator Dan Becker from Utah published a paper regarding making a case for court governance principles. And they put forth 11 specific principles in their paper, and those principles are embedded within this curriculum. And I'm not going to read through them all, but as making you understand, this is part of the curriculum that will be stressing the importance of making sure these components are part of your court governance structure. As I said, the well-defined structure, meaningful input. This last one, Can I see a show of hands? How many does that apply to right now in here? Show your hand back here. The last bullet. Selection of judicial leadership based on competency, not seniority or rotation. How many? One? Now, I'm not telling you, and this curriculum is not going to make everybody go home and say we have to do this. This is just one of the principles that the Chief Judge and Dan Becker identified as probably a good idea going forward. But I just want to point that out for you. These are some of the other principles that we focus on throughout the curriculum. Transparency, policy level issues. And it's interesting to know, court governance is not the tactical day-to-day management of your organization, but it is that 50,000-foot level and making sure that you look at the organization holistically and comprehensively. Also, it's important to have clear and well understood and respected roles and responsibilities among the governing entity. People should know what they need to be doing. And so should the rest of your organization. And this closes out the principles, a system that speaks with a single voice. This next one is also pretty important. How many of you have the authority to allocate and spend resources independently? Federal court, right? State court now, I'm sorry. You're in the federal court. How many else? So others don't? Interesting. So again, one of the principles that we should aspire to. I also want to just take a few minutes, and I'm not sure where I'm at in time, take a few minutes and talk about an important piece of this, and that is building the effective court structure. And in this section is probably the longest section of the curriculum, but it really goes into dealing with issues regarding your culture. Talks about some change management practices that are necessary, a necessary skill set, how you go about assessing your readiness. And as I said before, part of this curriculum includes a 2-page tool that one can use, and more than one can use. You can have the entire organization use it, but basically to show you where your weaknesses may be in developing or improving your governance structure. And the 6 steps that the curriculum sets forth will walk the participants through on how to do that. These are the 5 activities that I mentioned to you before. Again, I don't have an exercise for you to do right now because I don't think they're really any conducive to just doing it in this room, but focusing on applying court governance principles. I told you also already about the fair and free video and how that is used to facilitate particularly procedural fairness issues. Talk a lot, there's some examples of court governance models in there, and some exercises to assist individuals in developing them. The organizational readiness I already said, and then finally, there's an exercise on how one can plan as well as evaluate your organizations. These are both exercises that are done. Some are done individually, some are done as a group, some are done both. First individually and then as a group. This is the assessment, and again, you can't read it, but just to show you, it's just a very simple tool that was designed to really help you understand where your organization is at, understand the weaknesses, and close the gaps. That is included. It should also be noted, there are a lot of the resources that were used for this obviously came from the court world. And some of you who have read a lot will know a lot of the names and know a lot of the publications that were used. But I also used a lot of work from our partners in the nonprofit side, as well as some of the private entities, particularly on the change management stuff and stuff, the pieces in this and that, where I found some very interesting work that's being done. So I think that closes up my side of it as quick, but I wanted to open up to questions. We have about 10 or 15 minutes left. Questions for anyone? For either one of us? Julie?
The governance structure in Scottsdale, but I might be missing Sure. Could you talk a little bit more about how a governance structure can advance the rule of law?
Sure. In the curriculum, there's a discussion about how the governance structure can facilitate the principles of the rule of law. And again, I set forth that really there's 4 kind of principles around that I used in the curriculum, which is, the principles of rule of law, which are government and its agents must be accountable. So I use that accountability, that the governing board can bring accountability to the court, so that's a piece of it. Obviously, a piece of the rule of laws are to be applied evenly. So I think governance has a piece of that as well. Laws are enforced fairly. I think that's a major piece for governance within your organization. And the last piece I tie it to is justice is delivered by competent, ethical, and independent representatives, judges. And I think that also has a place within the court governance, within your court. So that's kind of how I tied that piece together. That makes sense? Any others? No questions in here?
Peter has one.
Peter.
I got a question for Jude. The curriculum on purposes of courts, for me personally, is a great curriculum. It's kind of the way my mind works, and I know everybody's. Your microphone.
Sorry. Go.
I was going to say the curriculum on purposes and responsibilities, for me personally, is a great curriculum. But that's kind of the way my mind works. I always start with the big picture. I try to learn from the big picture and then move to the lower stuff. I know there aren't a lot of learners that do that, and I'm wondering, for the people that do they get anxious around starting with this big picture? Is there some way you can engage them in a way when they think a little bit differently? They like to start with the details.
So I think that's a great question. I'll tell you that it comes up most in new employee orientations when you're teaching from the 20,000 foot level and people aren't actually connecting sometimes. So what we do is we drill it to the individual job. Start to ask somebody, what do you do? They'll say, I send out notices, no big deal. I type notices. Is a big deal, Let's go to the 14th Amendment. Let's go to the Due Process Clause, the right to timely and adequate notice. So what you do is try and take the jobs in the room, relate them to the core purposes of courts, and try and connect. All of a sudden, you make the connection that you bring the Constitution to life every day in what you're doing, typing your notices on your computer. And if you work at it for a while, when you start consulting and teaching more and more, there's not a job in the court system that you can't relate, to the core purposes of courts. And so that, we kind of talk about that all the time. And so it's one of the things that we do. And, it's even interesting when you do it on the international basis. Like Collins and I worked with a lot of judges from Nigeria and court staff from Nigeria, and having them relate to the core purposes of courts and to the rule of law. And so you can do it. You can do it for just about any job that's out there. But yeah, you got to work at it a little bit. But what I find, the more that we use game theory and a lot of other things like electronic word searches and everything else, people get engaged in the curriculum. So we're using a lot of different techniques now through the activities, which make it relevant. So, it's difficult like in one snippet, but, if you drill to the curriculum, you've got enough material there that you can extract pieces here, there, and everywhere for what you do. The other thing that I wanted to point out to you, if you're a NACM member, you got this particular book, The Core and Practice. If not, join NACM, you get it for $5. Otherwise you got to pay $10 for it. It's a really good document. It basically puts it all out there for you. But you can go to that website right there, nacmcore.org, and download any curriculum in full with all the resources and everything else. So it's all out there in the public domain. It's not copyrighted intentionally, so you can use it. Modify it. If you adapt any new uses for purposes, let me know. I'd be glad to add them to the resources for other folks. Jim, you're reporting, right?
Yes.
All right, so I believe in rewarding volunteerism, so I'm going to give you that copy of the book. Do you have it? There you go.
I have a question, and I'm not sure if this is on the same part, but how do you engage, you can engage your employees and train your employees and whatnot, but do you have suggestions, or do you practice engaging the judicial like the judges in this curriculum and how important these things are? Because, as you were saying, the typing of the notices, that's a very important job, but depending upon your judicial climate, different people get different jobs for different reasons. So how do you go about it, or is there something in place where you're starting to streamline this out and give it out to the judges and the judicial, not just the judicial leadership, but all the judges in your government?
So I do teach at Judicial College in New Jersey from time to time, and we've done some segments on this, and we've related it to both pieces. How court administration supports the work that the judges do and why it's important to use, and then the various roles in the courtroom. Sometimes, we need to explain to judges that they can write the most erudite opinion in the world, but unless they figure a way to incorporate it into a court order that can be entered into a computer system from time to time, it can't be operationalized. And so that's what, when you're talking to judges and, you relate it that way in terms of everything else that we do. And then as long as we, tie back to the rule of law all the time, it's in the mission statement for the New Jersey courts. So, like all the aspects, and what I do is boil it back to the mission statement. Ours says we're an independent branch of government constitutionally entrusted with the fair and just resolution of disputes. Why? In order to preserve the rule of law. So I take those three, take all those concepts in our mission statement, relate it back to the judges, and then tie it to what the staff do.
I will make one additional comment to your question. Paul DeLoche, who was the chair of the revision project of the Corps, is on the NASJA Advisory Committee, which is the National Association of State Judicial Educators. And he's going to be doing a webinar for their members July 27th, and it's for them only. So it will, after it is broadcast for them, it will also be on the NACM website. So it is getting out to them. But.
And I think part of your question was, how do you do this? And or were we answering your question?
I think so, but is it going out to the judges, number one, and then how do you get the judges to buy in?
Wow. Hey. Well,
you want me to take this race since your boss is here?
Yes, will you please do that?
Give her a mic.
Uh-oh, give her a mic. No, I wasn't going to give it to you.
But I got to stand next to you. My name's Janet Barton. I am the presiding judge on the Maricopa County Superior Court, and I'll try to answer your question for you. I will tell you, I think, and I can only speak for my court, which is a large court. I think judges believe that court admin does their job, judges do their job, court admin's there to assist the judges when they need help, but never the twain shall mix, so to speak. They don't interact on a day-to-day basis. I knew very little about what court administration did when I took over the role as our court's presiding judge. But what I will also tell you about judges is they're more than willing, at least on my court, to help out. So if you try to get them involved, we were doing strategic planning and they wanted judges on the committee. So all I had to do was send out an email to the bench and say, who's willing to come to these meetings? And we have now judges on every subgroup because they were all willing to participate. They just don't know that they're supposed to be involved in this area. But once you sit down and talk with them, particularly if you get your presiding judge to send it out, I think you'll find that they're more than willing to be engaged. They just don't understand at this point that you want them to be engaged, that they should be involved in your work any more than they probably feel that you guys should be involved in their work. But I think you just got to reach out to them and ask. I think they want to be involved. And I was amazed at how appreciative court admin was when we got judges involved, because it was just a matter of asking. So go out and reach out to them. I think you'll find that they will be willing to get involved.
Thank you. There's
Thank you very much.
another question up here?
Yeah, Judge, that's I appreciate hearing that from you, and it makes me wonder, when you say there, excuse me, are there's sort of an administrative side of operations and a judicial and adjudicatory side of things, and never the twain shall meet. It makes me wonder what you conceive in your mind as to what the activities are that go within each of those. I mean, it seems almost intuitive. Of course, adjudication, you're in court, you're issuing orders, you're presiding over matters, that sort of thing. But I'm not sure it's so clear in all districts and all jurisdictions. And it's interesting because I'm not really sure if I understood what the question had been over there, because it was sort of different than what I heard your response to it. I find that...
I thought you wanted to know how you get judges involved in the process.
So that was the question.
You can reach out and ask, and I agree, many judges want to participate. However, you might not always have that leadership role that they want changes and things.
As I am at a unique position here because I know both benches, and you're both right. You are both right. Believe me, there are issues within the culture that you have to deal with that are not present other places, and that's why there's at least in my curriculum, there's a piece about talking about culture. We can't ignore it. How do you deal with it? And you and I work together, and I know Ann Harry because she when I was in Pittsburgh, we worked together, and we went through a strategic planning process here. That was not easy, because a lot of, there was some pushback by certain people, but I think in the end, it did produce a very good report. Different from where I'm at now, where they are coming out, we're ready to go. Whatever you guys need will help. And so it's just a different type of approach. I'm sorry.
No, the only other thing I was going to say is that Mary McQueen's document on loosely coupled organizations and basically court governance from that perspective, kind of talks about taking that dual track to the next step. Creating the port where we can create a nexus for judges and court administrators and court managers working together, to accomplish the work. And she uses the gavel as the symbol, basically saying 2 heads, 1 body. And working together towards the overall mission. So I think she puts it very well in that Kennedy document. So that governance document, it's available on the state, on National Center website.
Kevin had a question here. I know he's been waiting patiently.
I just want to make a comment. I want to thank you all because this has been very good for me. The principal module you talked about being for maybe new employee orientation. And what I hear about the governance competency, I think that's going to be for judicial orientation. I have a brand new judge who wants to... is this being live streamed?
Yes.
Who wants to be involved. He wants to be involved. He feels like he needs to be, but I think he needs to understand that governance and how that works.
I think you're exactly right. The governance curriculum is written for judges and leadership judges and leaders, other court leaders. It really wasn't mapped out for a new orientation for a new employee coming in to your organization, unless that new employee was in the leadership role.
So I'll just leave you with one thought. We put all those materials out there for you to judiciously emulate in any way you see fit. I'm sorry, you could also phrase that shamelessly steal. Take whatever you want. It's there for your use, and I've had great degree of success, incorporating these materials into both local courses in the state of New Jersey and into, the ICM course I teach on purposes, as well as the MSU course that I teach on purposes. So I think you'll find that they work, with the people that you're teaching it on.
And just one follow-up comment. We just briefly touched on these two curricula. As you'll see when you go in there, there's a lot of material. There's a lot of resources. I did want to, I mentioned in the beginning, I'm the chair of the new core committee. If anybody's interested in the core committee, we have an in-person meeting tomorrow from 1 to 2 in rooms 310 and 311. We'd love to have you join the committee if you're interested. Thank you for coming.
Thank you all.
Thanks.